Hi, welcome to my channel and please don't forget to like, comment and subscribe. Today I bring a topic about improving fishery law enforcement in maritime protected areas. Many international and European legal instruments call for the establishment of marine protected areas or MPAs, both within and beyond national jurisdiction as a means to improve fishery management and to protect and preserve marine biological diversity. Tanaka on 2008. In parallel with this development, there is increasing concern at coastal state level about the effectiveness of MPAs in achieving their objectives. In this context, there appears to be some consensus among the marine law enforcement specialists that the efficacy of MPAs is very much dependent upon the system of monitoring, control and surveillance or MSCS that is implemented for such areas. Indeed, fishery law enforcement is at the heart of the Common Fisheries Policy, long and current on 2000. Accordingly, this article aims to identify the difficulties that must be overcome in order to improve the effectiveness of MCS in MPAs. The discussion commences with a brief review of some of the legal instruments which provide a legal basis for the establishment of MPAs in international and European law. This is followed by a brief analysis of some of the problems that stem from, inter alia, the absence of common definition in these instruments regarding the subject matter and characteristic of the area to be protected, the absence of harmonization of MCS in such areas, as well as the enforcement difficulties that arise from a practical considerations such as the size, shape, and location of MPAs. The article also reviews a number of fishery enforcement measures which the authors believe can improve the effectiveness of MPAs, including hydrofencing, special fishing permits, one-gear rule, as well as the establishment of specific monitoring systems and also security enforcement zones. Although the total harmonization of regulatory measures is desirable from a law enforcement also perspective, the article nonetheless concludes that it is also possible to have a specific MCS solutions tailored to meet the characteristic of the area that needs to be protected. At the outset, it should also be noted that the discussion is focused on the concept of MPAs in general and for that reason does not distinguish between protected areas within and beyond nation jurisdiction. The latter present a different range of practical and legal problems. And then the next is legal basis for MPAs in international and European law. There are several international and European legal instruments which provide a legal basis for the establishment of MPAs. As a start point, it may be recalled the Article 194 or 5 of the 1982 United Nations Convention on the Law of the Sea calls upon states acting jointly or individually to take measures which include those necessary to protect and also preserve rare or fragile ecosystems as well as the habitat of the depleted, threatened, or endangered species and other forms of marine life. Although the convention does not make reference to the term MPA per SE, Article 211.6 provides for the coastal states to take preventive measure in clearly defined area or special area of their exclusive economic zones or EEZs to combat vessel source pollution. Similarly, Article 234 of the Convention provides a legal basis for the adoption of measures and concerning vessel source pollution in iced cover areas of their EEZs. These measures and the considerable progress that has been made under MARPOL 73/77 and under the IMO guidelines for the identification of particularly sensitive sea areas fall outside the scope of this, which is focused on the establishment of MPAs for the protection and preservation of biodiversity, as well as for fishery management purposes as a mitigation tool against the effects of fishing activities on the marine ecosystems. The requirement to establish MPAs for the latter purposes and also received considerable impetus from the Johannesburg Plan of the implementation, which expressly calls upon states to establish a representative network of MPAs and time or area closures for the protection of nursery grounds consistent with international law and based on a scientific information by 2012. This requirement is also reflected in many United Nations General Assembly resolutions, which have consistently called upon states since 2002 to use diverse approaches and tools for the conserving and managing vulnerable marine ecosystems, including the establishment of representative networks of MPAs by the 2012 or Resolution 57 per 141 paras 51 and 53 or 59/240 paragraph 54. This is considerable evidence supporting the contention that the legal basis for the establishment of the MPAs predates both the 1982 UNCLOS and the Johannesburg Plan of Implementation. Indeed, several regional instruments, including the 1976 Protocol to Barcelona Convention, and provided the adoption of special management measures in the 1970s. So thank you for watching, and don't forget to like, comment, and subscribe.